This is Gary Berger for our Ask a Lawyer show today on July 15th. On July 15th. Happy Tax Day, everybody. Who knew that the middle of the summer would be tax day? What a crazy world we're living in that it's not in April, but it's in the middle of the summer in July, and it's been a hot one this week in St. Louis. I really want to thank my great coworker Genevieve for doing the Facebook Live show last week. She did a fantastic job. Everybody liked what she did. I got a lot of great comments and a lot of great feedback about the input that she gave. I'm a little bit worried she'll be taking over the show from here on out, but I wanted to do another one, so here I am back. Last week, Genevieve did it because last week I had the great chance to take my family to Colorado for a week. We had a great time. My brother lives in Denver. We go out there almost every summer. I love Colorado in the summer, the beautiful mountains. I did a lot of hiking. I made my kids do a lot of hiking. I drove there and back. So I think I set some PRs, some personal records in drive time because we didn't really stop. I brought my parents and we had a great time with my brother, just family time. We had a house we had rented in there. We had, it was great, very interesting. So we went to Crested Butte. Crested Butte had one of the highest incidents of COVID or Corona at the beginning of the pandemic. And then they really dealt with it well. And now they really are, they didn't just plateau the curve like a butte, right? They brought it down and over, and everybody in Crested Butte. I don't think there's many reported cases now. Everybody's wearing a mask. Signs in the stores, everybody could wear a mask. So, but it's just very interesting to see different people's attitudes. Although I understand it, I don't value or agree with the politicization of wearing a mask. Today or yesterday, our governor decided to start, he needs to try to gain political points with his supporters, so he's anti-mask now, or kind of brushing off wearing a mask. I've encountered many people, even in the middle of nowhere on hiking trails, wearing masks and really valuing protecting their health. I obviously don't know their personal health condition or who they're living with or their stuff. I also encountered people who were not wearing masks and kind of in your face, a little bit in our face about, a little bit in the face of the public about wearing masks, wearing their non-wearing publicly and proudly. So I'd be in a place with everybody wearing masks, but you could tell one family wasn't, and darn it, that was their right, and they weren't going to wear a mask. So that was one interesting observation that I had. Coming back, should I wear a mask? So the question becomes, should I wear a mask? I think I should wear a mask, so now I will wear a mask. There you go. Now I have my mask on. So we already have questions coming up on our feed, and I greatly appreciate them. People welcoming back, yes. And we didn't fly, we drove. Colorado's beautiful in the summer. If you don't, I've done I do. So the question is, so it's the pandemic, so what are you going to do with your kids or your family? Outdoor swimming if you can, a lake, river, pool, whatever you got. Hiking, I've been making my kids do a lot of hiking. For the 2 weeks before, Bob Stolzberg loves my mask. Bob lives out in the country. He moved to the country. He's my friend, one of the smartest computer guys and Alexa guy that I know of, and the only Alexa guy I know of. But I've done, so in the 2 to 3 weeks before my Colorado trip, me and my family, we hiked Babbler. We hiked the Lewis and Clark Trail. We hiked West Tyson, which is great. And we hiked the one off Reese Road in St. Louis County. Starts with a C, and I always mind blank it. I used to run that in high school. Someone will put it on my feed here, I'm sure. So, but enough about me. Let's see, questions about Any other questions about Colorado legal questions? Interestingly, you still have to sign a waiver when you do stuff. A lot of things were closed. We took the lift up and then we summited a peak there. Did a lot of long hikes. But a lot of things are closed, like the zip line courses and stuff are closed. We can't do that. But enough babbling and to begin. Let me cut right into some questions. Speaking of waivers, Adam asked a question. If you've had to sign a waiver to participate in an event and then get hurt, what happens? I assume the waiver protects the event organizer business, but can you still file an injury claim with your own insurance or something? Great question, Adam. And that's, so I signed waivers. And as I just said, to go on this ski lift, chair lift to the top of Crested Butte, beautiful. And then we hiked the rest of the 1.5 miles to the peak. At least one of my kids did. I had to bribe him with a little bit of money to do it, but he did. No, I'm kidding. My kids are great. I enjoy them. So if you sign a waiver to participate in events, you have to sign a waiver when you bring your kids to a party at a place like Bounce U or the trampoline places, or you go on a zip line as a kid, or you go on a roller skating rink, or you go ice skate, or rent it. Everybody wants you to sign a waiver. That is enforceable. And interestingly, it's even more enforceable in a mountain state. So the joke was, even 20 years ago, waivers may not be enforced everywhere, but they're enforced in mountain states, and they are. Because they don't want, the ski slopes don't want you to sue when you break your leg. Although there's great orthopedic surgeons in every ski town. You'd be amazed. So there are enforced. So if you sign a waiver, you are releasing that place from their negligence. So that the entity that has you sign the waiver, you release your claim against them. Now, however, you if they don't have the waiver, if they can't find the waiver 2 years later, then you can sue them. So it's important for businesses to keep the waivers. I've had cases where they say there's a waiver, but there isn't. I also work at a place in my second job as a dive instructor in Bonne Terre, Missouri, where we have everybody sign a waiver, and we keep those regularly. And so that's the issue with the waiver. It's a little bit unfair that you are waiving rights to future injuries when you don't know what they are. So there is due process rights, like substantive and procedural due process rights that you have. So you really should know basically what you're waiving. If you're going to go roller skating, it's fair to waive your rights to sue them if you fall roller skating. However, it's not really fair if you get food poisoning because after eating there, because that's not really what you had a claim for. But you do. Now, many places, though, even if you signed a waiver, have a provision where they will pay you med pay. So I know in a lot of places, they'll say you signed a waiver, you can't sue us for liability, but we have med pay provision for $10,000 and we'll pay your medical bills. So even if you were injured at a place and you signed a waiver, you make a claim for your medical bills because often places will pay that. And often they have a specific insurance provision for that. So do that. And then I see a question. So that's it. I assume the waiver protects the business, but can you still file can you file an injury claim with your own insurance? Not really, because any liability insurance you would have would only cover you if you were negligent and hurt someone else. However, you do have health insurance. You use your health insurance. That answers that question. Let me go. Let's keep going with questions. Casey asks a similar question. What do you think about public schools putting COVID releases in waivers? What about other places like gyms? Well, that's also another interesting waiver question. So like if you go to a gym and stuff, or your workout place that are kind of reopening, but now we have an increase in COVID cases, so now they're kind of closing. They're going to have you sign a waiver that would release you if you're if you're bench pressing or you're doing something, you slip on the treadmill, that kind of stuff. So there has been some recent news about putting COVID releases in a waiver. And specifically, I know there was some news stories this week about schools putting waivers for COVID for students. Now, that's interesting. Is what I understand, schools like Hazelwood and some other schools had added COVID and a COVID release for students participating in athletics. And in fact, I know that the insurance company for schools, Missouri United School Insurance Council, required schools to get, as part of their insurance with music, all caps, that's an acronym, to use waiver for those athletics. Students generally in a public school, they can't make you sign a waiver because you have a right to an education. They can't make you sign a waiver that they can be negligent and hurt your kid, and then you got to go to school there. That would not be fair. However, you don't have a right to participate in athletics, and athletics is voluntary, and not everybody does participate in athletics, and schools have to buy additional insurance and do additional things to provide athletics to their students. Although we all know, and I think agree, that athletics are important part of school. The team name, going to the football game, teaching everybody to live healthy lives. There's a lot of lessons you learn in life from athletics. So they're very valuable, and they certainly are educational. So as I understand it, and I would agree that the schools are taking the position that if you're going to do athletics, they're going to have you sign the COVID waiver. But if you're not, you don't have to sign a waiver. And that makes sense to me. It is also, it's hard for schools to manage this. It's hard for them to manage this, and it's going to be even harder when we open up with schools. And Howard, the issues that are involved in schools opening are there's a lot of issues. Are we going to be able to do it? Are some people going to go live? How are different live or on the internet? Are people going to be able to? How are different schools going to do stuff? Our federal government is not taking the leadership role that they need to. The Secretary of Education was on interviews this last weekend where she's saying CDC guidelines are discretionary or they're not mandatory, and that each school is going to do their own thing, and there's been a lack of leadership in my view, and I think there's clear. I mean, it's been kicked down to the state level, and then now the state people are going to kick it down to the local superintendents. So the poor superintendents of each school district have to figure out their own policy and procedure for the safety of the students and rely on the resources they can, just like every business has had to do that individually as well. It is what it is. I'll leave the politicians to argue about it more. But legally on this waiver, students are not required to participate in athletics. And let me get to that point. Sorry, to finish that point is, so the school also has to manage the students coming into the athletics. So they need to tell them, if you have a fever or you're symptomatic or you've been exposed to someone with COVID, don't come. So they need to have some type of additional agreement or way to message that to the students, so the students agree and kind of have a contract or an agreement with them, both to tell that to the students as well as to manage their liability. You don't want to have the whole football team getting sick with COVID. You don't want to have those claims for the school. So you need to both sign the waiver, and you need to have teach the students, if they are sick or think they've been exposed or engaging in risky behavior, not to get everybody else sick and keep them away from the team. Because you can imagine, I was a wrestler in high school or even running or anything else. I mean, you're going to, if someone else has it, you're going to get it. So you need to teach people about that and make it serious. The other thing is, schools, you're going to think you got it at school, but how do you know where that COVID transmission came from? That's going to be tough to track down. I don't think the contact testing and tracking is really where it needs to be. So the interesting waiver issues, Adam and Casey, with regard to schools requiring it as well. Other businesses can do that too. Schools have a high level of immunity, though. So there's also immunity issues with schools, meaning sovereign immunity. They're an agent of the government, and so they have certain sovereign immunity. I've written on this and lectured about this and argued cases in the Court of Appeals and other issues about where the line is on liability, because schools don't have sovereign immunity for auto accidents, premises liability cases, or cases in which they buy insurance. Music is the insurance policy for schools. So if they buy insurance to cover athletic injuries, then they don't have immunity, but they can still control that liability or attempt to with waivers. I fight waivers, but waivers are unfair in a way because you're agreeing in advance to not file a claim for someone's negligence. What if the school is really, really negligent? What if a teacher or superintendent, I'm not saying they do or should, but what if they, we have a case like this right now. I mean, what if they make kids practice when they can get sick and they injure kids? Or there's all kinds of bad stories about what some bad teachers do to some kids. And should they be liable for that? Why should making someone sign a waiver give them a get out of being responsible card? So you have to balance so as a society we balance the right of the school district to try to limit liability and limit exposure because it is our tax dollars and it's my tax dollars too. On the other hand, you don't want some terrible negligence or terrible action by a school person disproportionately financially affect one family. Why should one family and one person have to bear the brunt of a terrible injury and be financially on the hook for that? That's why you have insurance. That's why you balance those risks. That's why we pay premiums. That's why we pay taxes to public schools. So we balance the economic cost and then economic impact from that. So if one person's injured, they should be recovered for. They should have recovered for that. But then the cost of that gets balanced among everybody as a whole. That's the idea behind insurance in the first instance. Moving on, Brennan asks me, how hard do you think prosecutors and defense attorneys struggle with moral dilemma, or it's just part of their job? Brennan asks. So that's an interesting question, Brennan. They do. We have it all the time. I mean, prosecutors can't be overzealous. The Missouri Supreme Court recently, and this may be what you're referencing, Brennan, I don't know or not, but the Missouri Supreme Court just reversed an old conviction for prosecutorial misconduct. So we have an adversarial system, means we fight to win. I fight to win for my clients every day. I fight as hard as I can. And the other side's fighting hard against me. We're doing it all day to day. But in the criminal context, if a prosecutor's being overly zealous and over-representing the state, are they hiding evidence, bearing evidence that would be helpful to the defense, like other witnesses that saw him somewhere else or saw someone else do it or something like that? We have the Innocence Project of Spence and other people. I know a lawyer named Jay Ruan, on the East Coast who has gotten 3 people out of jail. He's a hard-working criminal defense lawyer, and one of his prides is finding innocent people and proving they're innocent and getting them out of jail. So an overzealous prosecutor can do that. Similarly, that's the moral dilemma. A defense attorney, I have many friends who are defense lawyers, and how do you defend a criminal when you think he might be guilty? Well, you believe in your heart of hearts that every person's entitled to a defense. I've referenced before in this program, our President John Adams, our second or third president, I think I got that wrong before, he represented and defended the British soldiers who shot and killed Americans at the Boston Tea Party. The sergeant was found guilty, but the frontline guys who were just following orders were not. Part of being a trial lawyer is defending everybody and believing everybody has a right to a vigorous defense and a zealous defense under the law. That's what my law license says. I have to zealously represent my clients. But the moral dilemma is when that goes too far. So we have ethics rules. Lawyers have ethics rules that govern us, that inform us as to how to navigate those tricky things. We have friends we bounce our ideas from. Most lawyers do the right thing. When they go over the line, you hear about it in the paper. Or later on, convictions get reversed. But it happens on both sides of the V, as we say, the versus in criminal defense lawyers. Maya asks, can a lawyer choose to drop a client at any point throughout a case? How do you handle situations where you don't feel comfortable representing someone? Would you represent them anyway? If you turn them down, would you refer them to someone else? What are some reasons you would not want to take on a client? There's a lot of questions in that. Thank you, Maya, for that question. So there's a number of ethics rules that govern this. I lecture and teach other lawyers about this on my Lawyer to Lawyer page on our website, Burger Law's website. We have different presentations on courses that I've taught to other lawyers about terminating representation. How do you do it? When do you do it? So with the caveat that I can do an hour-long speech on it, let me give you the 3.5-minute answer. I'm going to start myself. I'm going to get my watch out here. I'm going to find my timer. I'm going to go. Here's the 3.5-minute answer. Can a attorney choose to drop a client at any point throughout a case? Yes, they can. Now, you can't prejudice the client's rights in his case. So, for instance, what a lawyer would do if the case was filed suit, they would file a motion to withdraw. And if you write up like the day before trial, the judge isn't going to let you because that's unfair to the client. But yes, a lawyer in a civil case, let's not talk criminal, let's just talk civil, can drop a client. You either terminate the client, and if you terminate a client, you have to tell the client that they should go seek another lawyer, and you have to give them the statute of limitations time to file a lawsuit. So you may say, in Missouri, you have 5 years to file this this lawsuit. In a medical malpractice, you have 2 years. In a wrongful death case, you have 3 years. In Illinois, you have 2 years to file this lawsuit. You need to give them a date and tell them the time period in which they have to file a lawsuit, not get another lawyer, file a lawsuit. Typically, then I would file a motion to withdraw. I tell the client to get another lawyer. How do you handle situations where you don't feel comfortable representing someone? I don't take the case in the first instance. Money isn't worth it. So if I'm not comfortable representing someone, I don't take it. If I take a case where I think everything is hunky-dory and I'm representing a client and advocating for them, and I later find out information that caused me pause, caused me to not feel comfortable about that, then I typically withdraw from the case. I have an attorney-client privilege with the client, though, so it's not my job to go tell the defense lawyer why I'm doing it. I just withdraw from the case because I have to owe the duty to my client still because I have attorney-client privilege. When I file a motion to withdraw from a case, I don't say why I'm withdrawing. I say I'm withdrawing. That's it. I don't tell the other side. So that's what I'm doing. It's been a minute 40 seconds. Would you represent them anyway? The answer is no. If I'm not comfortable, it depends why I'm not comfortable. I mean, but if I don't feel comfortable, I've been doing this long enough and I have a lot of business. I'm blessed to work hard for my clients. And if I'm not comfortable representing someone, I don't do it. So the answer is no to that question. If you turn them down, would you refer them to someone else? Yes, I do. So sometimes I also say that, for instance, I can't take a case for you on a contingency fee basis because I just can't. The case isn't that value. You should go to someone else who may. You may find a younger, hungrier lawyer who's able to take that case. Or maybe it's a really hard case that I don't, because I've tried a lot of cases, I kind of think I know what wins and loses. I say, listen, I don't think I can win your case. Someone else might, though, and there's other bright, smart lawyers out there who may have a different view than me, and then go to that lawyer. There's other lawyers. And yes, I have a referral list of other lawyers who I know do, and there's cases that I don't take. I don't do a lot of criminal. I do family law. I don't do probate, trust, and estate. So I have other friends that I send them to for those and other good lawyers that I know. And I also have other subsequent emails when we reject a case or don't accept a case. I have a series of emails to clients that go out to them saying, have you looked on the Missouri Bar or Illinois Bar website? Is it a small consumer case? You want to go to Legal Services of Eastern Missouri for free legal help? What do you want to do? I got 15 more seconds. What are some of the reasons you may not want to take a client? If I don't think I'll win the case, if I don't think they need a lawyer, like I can't add value to a case, if they should just call and settle the case on their own, they'll put more money in their pocket. If it's a substantive legal area that I do, because I'm a niche lawyer, I represent injured people. I do class action work. I do wage and hour work. I've had some success there. We do a lot of personal injury, meaning malpractice, auto, truck, motorcycle crashes, workers' compensation, premises liability, slip and fall cases. So if it's not in my area, I don't do it. That's my 3.5 minutes. I'm done. All right. So next question. In a store like Davey asked, in a store like Walmart or Target, were you to stop and accuse? If a store was going to stop and accuse you of shoplifting, but you didn't shoplift, are you free to leave, or are they legally able to detain you until the police arrive to sort it out? They can detain you for a period of time. Security can. So if security thinks that you've stolen from them, they can detain you for a period of time. But the police ought to be able to be arrived in minutes. Now, if the store is wrong and you were wrongly accused and they didn't have a good basis to accuse you, then you have a legal claim against them for false imprisonment and libel slander. So the stores run a risk of stores can stop you from stealing their stuff, just like you at your home. You have someone leaving your house and they steal your French vase, then you're not going to let your drunk friend leave your house with some of your stuff or whatever, So a store can do that, but if they're wrong, they run a risk for civil liability for false imprisonment or slander libel claim. So they be careful. They better have good views. They better have it on videotape of you or of a customer. And I say you, Davey used that as an example. I'm using that as an example. So they better have good proof because you can sue them civilly. And they don't want to run a risk of that kind of liability. Next question is, Rodney says second. Sorry. I'm looking through to make sure I didn't miss anything. So, here's a question. So some of my DOC friends are asking me, yesterday was the Supreme Court hand-down day. There was no decision in the Supreme Court Department of Corrections overtime lawsuit. We look forward to seeing that. Michael's correct. July 28th is the next hand-down date. David asks me, how do you get a settlement past what the policy limits are? If they have $50,000 of coverage, how can a settlement or case victory award more than that? Great question, David. All right, so there's a number of ways to do that. Number one, so typically in an auto, motorcycle, truck, not a truck case, but auto, motorcycle, someone hits you, injures you. One of the first things we do is find out what the insurance policy limits are. If someone has a low limit of insurance, like $25,000 or $50,000, then that's all that the insurance company will pay for that defendant. So typically, that means the case is going to settle at that level. Now, and you're going to have to pardon me, I'm going to sneeze. Excuse me. So you're going to be limited at that recovery under most circumstances. Most people don't have the kind of assets that would warrant you ignoring those policy limits and going after the person personally. And it's also my experience that it's very difficult to collect against someone personally. I very rarely do it. I'm doing it on Friday, this Friday. I'll be taking a default judgment in a wrongful death case that I can talk to you about more after the hearing on this Friday. So I very rarely have done it. The last time I did it, I sued a company for discrimination. I won the case twice. Well, first time we mistried it. The second time I won it for pregnancy discrimination. I got a judgment for about 70 grand, 60 grand. We went and collected against the building that was owned by the person and company. We paid $500 to execute on it. We execute on it. It was sold on the courthouse steps for $500. So we made no money on that case, but I believed in the case. We had a letter saying that the woman was being fired because she was pregnant. So I'm going to try that case. So we did. So it's hard to do, and you end up losing money. There you go. Now I'm being asked. I just saw a question. And I'm going to come back to the other question. If you share an office with someone who is sneezing without a face mask, what should you do? All right. Now, Bob, this is my friend Bob, who is my office mate. Now I'm putting on my mask, Bob, so I hope you're happy. I did this earlier where you weren't watching, but I will not sneeze on you. Let me go back to my policy limits question. So if let's say someone has $50,000 in limits, but your damages are only $20,000 $25,000, $30,000, $40,000, you should settle that case. Let's say there's someone with a $50,000 limit, but your damages are $200,000, $300,000, or $400,000. Well, you may have underinsured motorist coverage, David. So what that means is you settle the case for the $50,000 that the underlying tortfeasor has. You make a underinsured claim against your own insurance policy, and then you litigate that or make that claim. You have to get permission from the underinsured carrier to settle the case. And I do that in number of cases, and we have a number of underinsured claims. Now, you would think sometimes that just because it's your own insurance company, you have underinsured coverage, that they're going to pay you well and settle the case. Sometimes it's often not the case. We have to sue people's insurance companies. I literally talked about that in my last newsletter. I had one. And if anybody wants to get our newsletter, we send every 2 weeks. Email me at gary@burgerlaw.com. I'm happy to put you on the list and get it. We talk about all kinds of case results and settlements and the details of them. Now, lastly, though, if you don't have underinsured and your damages are well over the $50,000 policy limits in this example, you do something called a bad faith claim. So what you do is you give the insurance company and the defendant an opportunity to settle the case within the policy limits, where you have to take it early on in the case or at the beginning. And then if the insurance company refuses to settle the case, then you can have a bad faith claim. And many times in those cases, you end up going to trial, trying the case against the against the underlying insured, and establishing the damages. And then you take an assignment from that person for the balance. It's called a bad faith claim. I've written about it. And there's good law in Missouri. And the reason why you can have a bad faith claim is it is unfair for an insurance company to deny a claim or not settle a claim in bad faith. So if an insurance company knows or has reason to know that that's a huge claim and they don't settle it, they shouldn't force an insured to go to trial with a low limit of policy and being exposed to the excess judgment. So let's keep on the same example. You got $50,000 in insurance. You injure someone, they got $1 million in damages. The insurance company shouldn't be able to refuse to settle and protect you. Go to trial. There's $1 million judgment. The insurance company pays $50,000, and you're stuck with $950,000 in liability. So that's why you have bad faith. So an insurance company cannot act in bad faith and refuse to settle a case or act reasonably in the settlement or adjustment of the case and have that all and have their bad faith conduct have their insured suffer the consequences of that instead of the insurance company. If an insurance company is going to be a jerk and not settle a case, if they want to roll the dice, they should pay the judgment. And that's the basic law and the well-reasoned law in the state of Missouri on bad faith. So I think that answers David's question. I got to bless you for my sneeze. I got Bob on the sneezing. I should have set that up better. I should have used that mask at a different time. Let me come to a new question from Maya. What are your thoughts on the use of NDAs by high-profile individuals and where things are heading with that? And Maya asked a couple of questions. So let me do that. So NDA means non-disclosure agreement. And we've had a host of people in the news where we have had chronic sexual harassers and bad people like Harvey Weinstein, the guys at Fox News who got kicked out, and those guys, what they did was they would serially victimize women typically, and then pay them money and then threaten them, and that they'd never have a career again unless they had to take this money and do that. And it's been in the news. I think they obviously are bad. I fight against confidentiality agreements and settlements. There's sometimes when they're appropriate. There's sometimes when they're not. I get in fights with other lawyers about that. So, I don't think it's good to use them. On the other hand, too, if you have a case, if you're the person who's victimized and you want to settle a case and they want to have a non-disclosure, then that's what they're going to do. There's other famous stories. I'm reading a book right now about certain of our current POTUS's fixers he's have over the years. So the other NDA they do is that if you have an accusation against an ND against a high-profile individual, someone like the Enquirer or somebody. So the owner of the Enquirer had a deal with our current president where the owner of the Enquirer would go buy up the stories from all the president's accusers and have them sign exclusive publication rights and then never publish it and bury it. And he'd pay $20,000-$30,000 for that. Did that with a number of our current president's accusers. It's written about extensively. I'm not making this up. And then they wouldn't pay for it. So they had this ongoing relationship where the POTUS would help him with stuff, and he would find and then Cohen would set up a deal. Dick Cohen, who was prosecuted and convicted, would set up deals where they would not publish it. That's another kind of NDA. It squashes public information. And then, look, on the one hand, companies should be able to settle claims and have it done privately. I get that. But on the other hand, when you have serial sexual predators that do this, it becomes a real abuse, and they're really terrible because then new people coming into the workplace and coming in that situation don't know about it, and they don't have that information, and it enables serial predators to do this. I mean, I don't want to go the wrong way on this and alienate anybody, but the Catholic Church did this for years and protected abuse by priests. And so when the use of these, yes, they're freely negotiating. Yes, it's a contract. But when the use of this is to let predators go out and still attack, harm people, it's terrible. It's terrible. We can't let that happen. So that's what I think. What solutions are being put in place or could be put in place to differentiate between companies protecting their intellectual property and powerful people abusing others and using it as a tool to keep them quiet? I didn't even read the second question, Maya, but you and I are thinking the exact same thing. You can tell with my answer. So I don't think a lot of solutions are being put in place to handle this. I don't know of any. I mean, the only solutions you could have would be federal or state legislation that would prohibit that, and we don't have that. And we ask and put pressure on politicians to release people from the NDAs. I know that was a issue with when Mayor Bloomberg was running for president, and this happens on both sides of the political aisle. Just because I spoke about our current POTUS does not mean I'm ignorant to the idea that sexual predators and people who predatorially use NDAs, it's on both sides of the political aisle. It's not one group or another. Some of these, and it's always men, right? It's not women. It's always men. These powerful men. I almost said white men. It's mostly white men. I don't know, but these powerful men think they can do that and use these NDAs and throw money at them, folks, to keep them quiet. And if you're about to get fired and you're a young woman and you don't have any money and you got high college debt, who's not going to take a bunch of money and not talk about it? I think most people would. It's a rational decision. But then the next woman who takes that young girl's job is going to be subject to the same treatment. Davey, let's move on with questions because I've been going about 40 minutes now, and I need to move through the rest of these questions. Are there any situations where you'd recommend someone represent themselves rather than hiring a lawyer? Absolutely, Davey. Yes. If you're in an accident, you just have one ER visit or something like that. I as a lawyer cannot add value to your case. If you have a contract dispute with the guy that cuts your lawn, or did some work, or you bought a car, paid $100 from a car for someone, go to small claims court, in your local courthouse, and for $25 you can file your own lawsuit, fill out the forms, and do that. And because you don't want to pay a lawyer, you don't want to waste money with a lawyer. So it's a low value case, take the law in your own hands with our legal system as much as you can and avail yourself of that. But if it's a case where, and I tell this to people all the time, I say, here's a case where I can add value to your case. Here's a case where I can't. And we talked at the beginning of this talk a little bit earlier about when I terminate a client or when I don't take a case. If I can't add value to your case with my contingency or percentage fee, which is how I charge most of my folks, then I'm not going to take your case because I want to make my clients happy all the time. Brennan asked me, have you ever had to call BS on a person's real injury claim? What are you obligated to do if you know it's staged? Yes, I have. I had a case one time where my client slipped and fell. We got the videotape. She said, I slipped and fell at this, I don't want to talk about the parties, at this gas station. We got the videotape, and I don't remember if it was after we filed suit or in the claim stage. And she said there was no wet floor signs, there was nothing. I had no way to know, and I really hurt myself when we got the videotape. And my client fell literally in the middle of 3 wet floor signs right around her. And as soon as I saw that, I said, listen, you knew about it. You knew this floor was wet. And so I've terminated that client. Now, I've had other cases where when I discover, if I ever discover that a client is exaggerating a claim or liability, or they didn't happen, or they hid other prior claims, I terminate the client. I think that's my duty to do, and I don't want to represent those folks. So I get rid of those cases. What am I obligated to do if I know it's staged? I've never had a case where it was totally staged. I have had cases where I look at it and the liability isn't what I thought it was. Even the case example that I gave you, that woman really slipped and she did get hurt. But if the issue was, did she have a reason to think if she was going to be comparatively at fault? And the answer was yes. So I didn't feel comfortable with that. If it's staged, I have an attorney-client. It's hard as a lawyer. You have an attorney-client privilege not to disclose confidential information. So I can't do that. Now, the reality is these defendants aren't paying money out easy. So if a case is staged, they're going to know about it. And they'll tell you. They'll say, hey, listen, this is a BS case. Your client's making it up. And I say, well, what evidence do you have for it? And they tell me. And I'll say, no, you're making it up. The client really got injured. Or I'll say, you know what, you're right. And then we won't pursue the case. So there you go. Thank you for posting some of these articles about tactics the insurance company uses will cheat me out of a settlement. You got to remember, too, that just because the insurance company says it's a staged case or something, that doesn't mean it's true. Insurance companies do that all the time, or they'll say you'll be at fault when you really aren't at fault. So I did an article one time, and they put it up in the comments section here about what tactics the insurance company will use to cheat me out of a settlement. They'll tell you that you already blew the statute when you did. They'll tell you the policy limits are low when they're not. They'll tell you, well, you can only get med pay. That's not true. You can get more than that. They'll say that that you were at fault when you're not. And they're going to say that you don't have to pay. We only have to pay for 30 days after treatment. That's not true. They'll say your surgery was because of pre-existing conditions when that was not true. They'll say we took a record. I have a case right now. I can give you war stories about each one of these facts down to the detail. I have a case right now where they said they took a statement of someone, blah, blah, blah. The client came to me. I said, well, is it true? They said, no. I said, well, then that's bullshit. And we went and filed suit. We're going to win that case. So I'm not saying every insurance company does that, but I have multiple examples of insurance adjusters saying what they need to do to get a case settled on the cheap early. You're at fault, so you can't recover, or you don't get to recover. You don't get to recover medical expenses because you have health insurance. Not true. You don't get to recover wage loss damages because you have sick pay. Not true. So they'll challenge claimants on liability They'll challenge claimants on statute of limitations. They'll challenge claimants on liability of conveyor fault. They'll challenge claimants on the damages they're entitled to recover, and a lot of it's BS. And you need to call, and we have all this on our website, and we'll answer any questions for free if you have a specific question. Rodney asked me, how do you deal with the stress of so many cases and so many deeply involved cases requiring attention? I work a lot, and I have great employees who work for me to help me with this. So I do have a little bit of a stressful job, but how blessed am I to have what I have? I mean, I got my own practice. I got great people that work for me. I have a beautiful family and all this stuff. I mean, I'm lucky to do it. And so some of these cases requiring attention really can inspire me. Some of the cases where I have to work the hardest are the most motivating for me. But one of the dealing with the stress, and I've talked about this before, that God grant me the serenity to accept the things I cannot change, the courage to change the things I can, and the wisdom to know the difference. So in the beginning of my practice, I would tilt at the windmills, to reference Don Quixote, of cases with bad facts or things I couldn't change. And the more I do it, I say, listen, I can't change the facts. What I can do is change how I deal with them and how I represent and help my clients. So what happens, Rodney, is for a plaintiff to succeed in a claim, they got to jump through a lot of hoops. If they ever fail at a hoop, they lose the case. And it's my job to make it through the hoops. But so there you go. It's a great question on stress. We all have stress. You know, I'm not the only one with stress. Everybody's got stress, especially during this pandemic time. Everybody's got their own stress at their own time. I lectured on this 3 weeks ago in a CLE to other lawyers about how do you deal with stress. That's where we have drug addiction, and when we have drug and alcohol addiction, people coping with stress. That's when we have, humans deal with stress. We have these cavemen brains that, and you got to deal with your own stress and your only internally mentally created problems. So we got to go out and work out. We have to get out of our own head, get out of our own way. We have to relax ourselves. Say the serenity prayer, work on gratitude lists. So you can have the same facts in your life, and one day your life sucks, the next day your life's great. It's what people with bipolar do, or depression. So you got to deal with those things. Everybody's got a little bit of it. So I have good days and bad days. You got to learn yourself too. What relieves your stress? Is it meditation? I've done transcendental meditation since I was in college. There's other types of meditation you can do. Is it yoga? Is it working out? You got to move the serotonin out of your brain with working out. We learn. You want to share your feelings. Sometimes therapy is very beneficial to people. You get marital therapy, marriage therapy, or individual therapy, or friends that you have that you can bounce stuff off of. Am I really right here? What's the perspective on that? Having friend groups that, everybody's got their friend that they can, God, can you believe what happened today? Boy, did I have a day. And then the other two, so I can give you all kinds of let go, let God, sorry, what the big book says for people in AA and addiction is that it's a spiritual malady and needs a spiritual solution. So praying to God and turning over your problems to your higher power and accepting that religion can be very powerful for dealing with stress. Everybody's got their different methods to do it. And I encourage people to, and me teaching my kids, I have a son going off to college, and I think about my kids is trying to teach them about lifelong methods to handle and deal with stress. But everybody clicks their own way. Some people, the guy who is the marathon runner and is in great shape and stuff, maybe he needs to run because that's the only way he can stay sane and keep and chill out, and maybe the person who goes to church has that too. So we all have our demons. We all have our stuff. We want to acknowledge it. We want to talk about it. A lot of people don't like to. I have this joke that when I do CLEs on ethics, I say, 1 out of 5 lawyers in this room is a drug addict or an alcoholic, and no one wants to talk about it. So but the truth is 100% of the people in that room have stress, and that's true. So the more we talk about stress, mental health issues, those things, the better for people. So I've waxed on a little bit about that, but I appreciate your question, Rodney. What things have you learned about human behavior during your career? Like most people, honest, is it obvious to you when some people is lying? It's not obvious when people are lying. Most people are honest. But remember that one person's terrorist is another person's freedom fighter. So everybody's got perspective too. So some people, I've learned a lot about human behavior. So most people are honest. And yes, I can tell when people are lying, but I've done that. I've also read books about lying. I've incorporated, what's my book on lying that I like? I'll remember in a minute. It's in my books. I'll look it up. There's great books online. They say people lie 10 times a day, or prevaricate. Sometimes it's minor, sometimes it's major. What's a white lie? Do you tell did I tell my 2-year-old son I was leaving for the day and wasn't going to see him for 8 hours? No. Interestingly, when you swear to tell, there's multiple types of lying. I swear to tell the truth, the whole truth, and nothing but the truth. So I'm going to tell the truth, meaning I'm not going to lie. The whole truth. Well, what if I say, I was driving and I came up to and I approached it and the light was green. Well, what I didn't tell you was, as I was approaching, it was green, but then it turned red and I blew it anyway and I hit somebody. So sometimes people don't use the whole truth or very carefully say things so that, and nothing but the truth. So you may circulate truths with lies, that kind of stuff. Spy the Lie. Spy the Lie is a great book. If you want to read the best book there is online, read Spy the Lie. It's written by a CIA interrogator, a person who did the truth tests that they do where they hook you up, or whatever those are called, and then an FBI guy. And the stories they have about how people that would lie would be amazing. And they take great examples. They take the OJ. So here's one thing I learned. So what they say is when OJ was interrogated, the example of the whole truth and nothing but the truth, that's like when President Clinton said, I did not have sex with that woman. Well, it wasn't the whole truth. But they had, so people, the question is, where are people going to put the line online, L-I-N-E, online? So here's what I do in depositions. I take some lessons from this. So they said that OJ had, thank you, Polygraph Maya, they had 45 minutes with OJ before he lawyered up, and they say had Furman and that other lawyer asked him different questions, it might have gone different. So what they asked him was your car was in Nicole's neighborhood? And he denied it because he knew they were going after him. But what they say they should have said is, if we have witnesses who will claim that your car was in Nicole's neighborhood that night, why would those people say that? And then it takes people a minute to say, well, wait a minute, why would they do it? And then they make a real reason why they may say that there was someone that. So I use that technique. I come from left field a lot. Anyway, I know I could do a whole show on human behavior. If you want more examples about that, Adam, ask me next time. And sometimes it's not obvious when people are lying. I tend to believe in the good in people, and then I figure it out later. If I always do the let them fool me once, fool me once, that's fine, but I don't want to get fooled twice. Are people on those electric scooters legally considered vehicles or pedestrians? I ask because there are bike lanes in a lot of places. I've seen them riding, but I also see them riding on sidewalks. People on scooters should be on streets. They should not, but streets are for pedestrians. Sidewalks are for pedestrians. Streets are for scooters and bikes. Now, people use them other ways, and if it's unsafe on a street, I can see that, but I don't like people on scooters on sidewalks, and I don't like people on bikes on sidewalks. They should be on the streets, and cars should share the road. Thank you for the step by it. So then we, on the comments section, we have, I think I got to all the questions today. We have different sites in our comments section. Anybody can read them. We have sites to different FAQs, how a lawsuit works, different stuff. Thanks, David Clive, for putting that up. I appreciate that. It's been about almost an hour, so I'm going to end this one. Come back next week for another Lawyer v. Lawyer show. These are getting some attention, so we're going to keep doing them. I should have some guests on, though. Make it more interesting than just me or Genevieve or I. If you have other questions between now and next week, email me, Gary@burgerlaw.com. We always answer your questions for free. If we're not able to find an answer for you, we'll shoot you to someone who can. Thanks for everybody for watching. That's all I have. Have a great week, everybody.